Great, thank you. All right, so good afternoon, everyone. I'm Andrea Barton-Rees. I am the CEO of Connecticut's Paid Leave Authority. And with me today is our Executive Assistant, Amber Forrest, and I will be providing a presentation on Connecticut Paid Leave. So this one, if you've attended those in the past, is a bit different. So this one is going to cover not only the basics of paid leave, it will also cover the basics of family and medical leave, and it will review some of the things that you need to know in order to implement the family medical leave and to have your employees or workers access the paid leave benefit. So if you're familiar with all of this because you're an HR professional, then I ask for your patience as we run through the basics, but many people we've noticed who are attending don't have a lot of this background, so we're going to go ahead and work with the basics. So just give me a moment to share my screen and we will go from there. Okay. You start at the top.
We can see your screen, Andrea.
Thank you. I want to make sure that we start at the top. And start from the beginning. All right. There we go. So this is how paid leave applies to your business, and this is a tool for HR professionals. Just a little bit about me. I started with the Paid Leave Authority last March. I did run a large nonprofit for people with intellectual disabilities before I came to the Paid Leave Authority. Today we'll talk about the program itself. As I mentioned before, what's family medical leave? How does that work with paid leave, implementing the Paid Leave Act, and reviewing how family and medical leave will work because it will change starting next year, just a few months from now. We'll show you where you can find additional resources, and then we'll have some time for questions and answers. What Amber will reiterate and what I'll say again, what I'll say now is please use the Q&A feature for questions. We cannot track them in the chat. And the raising of the hand feature is also another that we cannot use. So please just use the Q&A feature for anything that you would like to ask, and we'll answer those when we're done. So a bit about the Paid Leave Authority. It serves a growing need in providing financial relief to families, and those families, along with individuals, to care for a loved one or themselves without having to worry about losing any income. We have 5 responsibilities at the authority. They include outreach and engagement, including our webinars today in the series that we're hosting through the end of the year. We are responsible for developing the policies and the procedures that are needed to run the program. We also established the trust fund contribution rate, which is 0.5%, and we receive those contributions, which are held at the Office of the Treasurer in the Paid Leave Trust Fund. We approve and audit all private plans. There are approximately 365 of those right now, meaning private employers who have opted to replicate the CT Paid Leave program under the terms and conditions that are in the statute. And finally, we administer claims for paid leave benefits. Here are some of the key dates that you should be aware of. As you know, registration started last November, so about a year ago, and payments are due every quarter with a 30-day grace period after the end of the quarter. Starting in December, just a few, really 56 days from now, but who's counting, that we will be able to accept applications for benefits, and really not before that time, but starting on December 1st. And then on January 1, those approved claims will be eligible for payment. A bit about who's covered by the paid leave law. Those that are covered are employers that have 1 or more employees, and that does include those that are not-for-profit entities and private sector employees and employers that have unionized workforces. Sole proprietors and self-employed individuals may opt into the program, but if they do so, they have to remain in for a minimum of 3 years. Those who are not covered by the program include those that work for the federal government and the state of Connecticut, except those that are covered public employees. Municipalities and local or regional boards of education are also excluded unless they too have covered public employees, and the same is true for those that work in the state of Connecticut. Non-public elementary or secondary schools are always excluded as they have not been covered by family and medical leave. There are other entities that also may not participate in the program as a result of other laws. Often those are due to interstate commerce rules and statutes, and they can include railroad workers, those who work for governments of other states or sovereign nations, or they're engaged in interstate commerce. They may work in Connecticut, but they live in other states. Often we find this with those who are truck drivers, long-haul truck drivers, and the spouses of active military members who continue to pay taxes in their home state instead of where they may be currently deployed. A bit about covered public employees. They are defined as follows. They are either the non-unionized employees of the state of Connecticut, or if they are unionized, they are those who have collectively bargained to be included in the paid leave program. If one is an employee of a municipality or a local or regional board of education, and the unionized employees vote to participate in the plan, then everyone who works at the municipality or the local or regional board of education is then included, whether they are union or non-union. As you can see here, municipality has an extensive definition which follows what we normally think of, which would be a town, a city, or a borough, but it can also include a taxing district or a fire district or a regional council of governments. Let's talk a bit about how the contributions are managed. Starting in January of this year, employers of one or more employees that are covered under the statute were required to withhold 0.5% of wages and remit those wages to the Paid Leave Authority. Those wages are post-tax based on FICA, and they are capped at the Social Security contribution rate of $142,800 this year. Those wages are then remitted to the Paid Leave Authority. Those contributions, I should say, are remitted to the Paid Leave Authority, and we validate those contributions based on information that we have available to us through a number of state agencies, including the Department of Labor and the Department of Revenue Services. We then deposit those contributions directly into the Paid Leave Trust Fund, which is held by the Office of the Treasurer, and those funds are what is used to pay the paid leave benefits, which start in January of next year. Earlier, I referred to the differences between family and medical leave and Connecticut paid leave. Let's start by talking about what FMLA is. It does stand for the Family and Medical Leave Act. There is both a federal and state version of the Family and Medical Leave Act, and both allow employees to take time away from work to care for their family members or themselves for specific reasons, and that time away is job protected, meaning they have the right to return to their job, same pay, same standard, same working hours as they had before they took leave under family and under the FMLA, whether state or federal. As we sit here today, both federal and state FMLA are unpaid. So if someone took FMLA starting right now, that leave would be unpaid. Some employers do cover that leave by allowing people to use either their accrued leave, or some large employers that we know of actually have their own paid leave program. But many employers, they do require their employees to use their sick or their vacation or other PTO while they're out on FMLA. And this, however, will change significantly for the state law, not the federal, starting next year. Currently, this is what FMLA looks like and what it will look like starting in January. Right now, an employer has to have 75 or more employees to be covered by the Connecticut FMLA. And in order for the employee to access that benefit, that job protected leave, they had to have worked for their employer for at least 12 months, didn't have to be consecutive, and 1,000 hours. And right before they apply for the leave, and then the job protection attaches after 12 months of employment. They would be eligible for 16 weeks of leave in a 24-month period and 26 weeks of leave for military caregiver leave. And another critical issue here is that the employer can require the employee to use all of their accrued time off to pay for the time that they're away as a form of income replacement under FMLA. When the law changes in January, there will be some significant changes. And that includes that the law will apply to employers with one or more employees. There will be no hours worked requirement, which means that employees who take time off for a valid reason under the statute for Connecticut Family and Medical Leave will have no hours worked requirement, and they will enjoy job protection after 3 months rather than 12. There will be 12 weeks of leave in a 12-month period. The 26 weeks of leave for military caregiver leave remains, but there may be an additional 2 weeks of leave available if a woman is experiencing incapacitation during her pregnancy. Finally, while now an employer can require an employee to exhaust all of their accrued time to pay for the time that they are out in a form of wage replacement, they can still require an employee to use their accrued time, but starting next year, they have to allow them to keep up to 2 weeks of their accrued paid time off. So then what is Connecticut paid leave? We use CTPL, and it stands for a number of things: the statute itself, which is the Paid Leave Act, the program, or the agency. And it is a Connecticut law that creates a source of income replacement benefits for those employees that are eligible and can't work for reasons that are stated in the statute. Unlike FMLA, it does not provide any job protected leave. So a person could possibly be eligible for Connecticut paid leave, but not have worked for their employer long enough to enjoy job protection. And the agency, meaning CTPL, is not responsible for that. It's also referred to as PFML, or paid family and medical leave. Here are the reasons for leave under the statute, and these, with the exception of the last bullet, apply to both federal and state. You can take leave for a serious health condition, your own or that of a family member, and your own serious health condition can include pregnancy or serving as an organ or bone marrow donor. You can take leave to build your family through birth, adoption, or foster care. So let me just back up a second. These reasons for leave apply to family and medical leave under Connecticut. Let me make sure I correct myself. And they're also the same reasons why you can take leave under the paid family leave statute. The federal may vary just a bit. So I want to make sure I was clear about that. You can take leave to care for a family member who's been injured during active duty. That's also known as military caregiver leave, and to attend to specific reasons, and issues associated with a parent, spouse, or child being deployed overseas, and that is also known as qualifying exigency leave. What is unique to Connecticut, however, is the ability to take leave to attend to specific issues that are related to family violence. Our state has a Family Violence Leave Act, which allows a person to take up to 12 unpaid days to attend to issues related to family violence, and that might be relocation, court appearances, and the like. Those are currently unpaid under that statute, but starting next year, up to 12 days of family violence leave may be taken, and a person can apply to the Paid Leave Authority to have wage replacement for those days. Let's talk a bit about caregiver leave. So the law looked very different, and it does as we sit here today. For caregiver leave under federal and state law was really limited to a parent, a spouse, or a son or daughter that was under 18, or if they were over 18, you could take leave to care for them if they had a disability. When the law changes next year, that will be very different. Caregiver leave will have an expansive definition, not only of the people that you can define as family, but those who are covered under it. So it will now include a parent, a spouse, and a son or a daughter of any age, your siblings, grandparents, grandchildren, or a person who is related to you by affinity. And let's talk a little bit about what it means. Related by affinity, as you can see here, is really any person with whom the employee has a significant personal bond that's like family, that's listed in the statute, the slide that I just covered, regardless of whether or not they have a biological or legal relationship. We often find this in families that may have been raised in a foster home, and they're very close, say, to their foster sibling. They may have lived with them for a number of years. They're not related by blood or a legal relationship, but they consider one another family. Another example would be people who have lived together for a significant period of time. They may raise children together, they may own property, they may be the beneficiary of one another's life insurance policies, but they are not married. And they too would be considered to have a relationship by affinity that with the appropriate documentation, which will be defined by the Department of Labor, they would be able to apply for and, if qualified, receive benefits for paid leave. They would also be able to take time under the statute for family and medical leave, whether they chose to be paid for that or not. Here's a quick summary of the eligibility requirements under each of the family and medical leave statutes. The federal FMLA for job protected leave remains the same. You must work 12 months and at least 1,250 hours before you can take any job protected leave. As I mentioned earlier, for Connecticut, you do have to work for your employer for at least 3 months to enjoy job protection, but there is no hours worked requirement. To access paid leave benefits, however, you had to have earned at least $2,325 in the highest earning quarter in the first 4 of the 5 past completed quarters, and you can do that from 1 or more employers. You have to have a qualifying reason for leave, as I listed earlier, and you have to either be currently employed and working in the state, maybe you were previously employed and you've been working in the 12 weeks immediately prior to the time that you applied for leave, or you're a sole proprietor or self-employed individual that lives in the state. This is the one category of person who's covered by the statute that has a residency requirement, and you've opted to participate in the paid leave plan. Just a brief summary of the entitlements, which I've reviewed earlier. Federal FMLA remains the same, as we know right now. Job protected leave for family and medical leave is the 12 weeks, 26 weeks for caregiver, the 12 days that I mentioned before, and the eligibility for up to 2 more weeks for a woman who is experiencing incapacitation during the pregnancy. Those same reasons for leave are those that allow a person to access and apply for and seek approval of paid leave benefits. Now, how do you implement the Paid Leave Act? Let's talk about the responsibilities that you have for contributions, and then we'll talk about the responsibilities for benefits in the categories of those that have responsibilities under the statutes. First, let's talk about the workers. They are responsible for contributing 0.5% of their FICA wages up to the Social Security contribution limit, which I mentioned is about $142,000. Employers need to create an account at ctpayleave.org. They are also responsible for deducting that 0.5% and remitting it to the Paid Leave Authority. We at the authority are responsible for receiving and reconciling those contributions. We process any over or underpayments and interface with either a third-party administrator or the employer directly to reconcile those over or underpayments. And we do have statutory authority to impose penalties for noncompliance. The Connecticut Department of Labor is responsible for determining whether an employer who has not yet withheld the 0.5% or has withheld less than 0.5% for whatever reason that might be, whether they can continue to withhold or go back and catch up to the beginning of January so that they're current with their contributions. And that will be dependent on the general wage and hour authority that the Department of Labor has. All right, so then let's talk a little bit about claims, which are coming up very quickly. The worker's responsibility in applying for the claim is that they have to submit an application to the Paid Leave Authority in a timely fashion. To do that, they will have to create an account, and that is for security purposes, because they will be submitting very sensitive documentation in some cases in order to access the paid leave benefit. And we will be asking them to do that. They will also be responsible for continuing to update that account with absence information, particularly if they're taking intermittent leave, and information about any other sources of income, which may be multiple jobs. It could be short-term or long-term disability offered by the employer as examples. They must notify their employer about the fact that they've either applied for a claim through the Paid Leave Authority or they've received claim benefits and that they will be taking that leave. The employer will be responsible for completing and submitting an employment verification form that will be supplied to you by the worker as part of the worker's welcome packet. The employer is also responsible for validating absences and any other sources of income that the Paid Leave Authority will be asking for in order to determine how much benefit the worker should get, because by statute, they cannot receive more than 100% of their base weekly earnings. The employer is also responsible for notifying the worker about its own paid time off policies, including any short-term disability policies, any call-in requirements, any of those things. Then that's what the employer is responsible for, and to refrain from inadvertent or overt discrimination and retaliation against the worker for accessing or taking paid leave. The authority, along with our vendor partner, Aflac, is responsible for determining eligibility for paid leave benefits. We collect that supporting documentation and approve and deny the claims as appropriate. We're responsible for calculating and paying the benefit and monitoring the claims, and we do assess requests for reconsideration if a person's claim is initially denied. We do place a significant emphasis on investigating potential fraud, and under our statute, we do have the right to impose penalties for fraud as appropriate. If a person applies for a paid leave benefit and that claim is denied, they have the right by statute to go to the Department of Labor and have an appeal filed and heard. And that is the sole purview of the DOL. Talk a bit about how income replacement benefits work and what that process looks like. So we're going to get into a little bit more detail here. So the worker submits a claim, and they do that in 3 ways. They need to create a ct.gov account, as I mentioned, for their protection if they're going to apply online. You can also apply by email, by fax, and by mail. They'll submit an application. That application will have a checklist of all of the things that they need to provide. Some examples of those you see here, which would include the reason for the claim, the length of leave, and whether or not there are any other jobs that the person might hold, so we can determine what the level of benefit paid should be. Aflac will be determining that eligibility with oversight by the Paid Leave Authority. If they determine that the worker isn't eligible, they're going to let them know that and give them the information they need to notify them of their right to request a reconsideration. If they determine that the claim is in fact approved, then they continue to receive the reporting documentation. They'll let the worker know if any documentation is missing, but if the claim is denied, then they too notify the worker of their right to request a reconsideration. Aflac calculates the benefit using DOL and other data sources, and also other income that particular worker might have. They issue the benefit payments, and it is done in 2 ways, 2 forms. It is either on a debit card, also known as a stored value card, or is in a direct electronic transfer to the to the claimant's bank account. There are no checks issued at all, because issuing checks is it is not the best way to help avoid fraud. So we're avoiding checks because they can be taken out of mailboxes and the like. But benefits will be paid each Tuesday, 2 weeks in arrears. So as an example, if a person is eligible for benefits that start on January 2nd of next year through January 8th, those benefit payments will be issued on January 18th. We will also let the worker know if we're making any changes, but the worker has the responsibility to let us know if there are any changes to their circumstances that may affect their benefit. And that would include the start or end date of their leave, if they're taking intermittent leave, if there's a change, any change to their employment whatsoever. They have a responsibility under the statute to tell us about those changes. Exactly how much would a worker get once they apply for benefits and those are paid? If they're receiving less than or equal to the minimum wage, then they essentially get 95% of their base weekly earnings. If they receive more than that, they get 95% of their minimum wage times 40 plus 60% of the difference between what they make and what that number is. And essentially, they can't get more than 60 times the prevailing minimum wage, which right now is $13 an hour, so they won't get more than $780 a week. A couple of examples of how that works here. So worker A makes $13 an hour. Simple to calculate their base weekly earnings. Their benefit is 95% of that. They get $494 a week. Worker B earns a bit more than the minimum wage. You can see here, their base weekly earnings is $540. So what they will get is 95% of that $540 plus 60% of the difference of what they earn and what the base and the $520, and that gives us $506 a week. So let's talk a bit about how employer-provided PTO and other benefits work with Connecticut paid leave benefits. So a bit here. So again, as I mentioned earlier, the employer, when the law changes next year, can still require the employee to use their sick or other paid time off while they're out on FMLA, but they cannot compel them to exhaust their leave. They do have to allow them to keep up to 2 weeks. What we are telling employers is if you have a bank of PTO and it doesn't matter how your employer uses it, then they just keep that bank of the PTO. The reason that this section of the statute exists is because during the time that the statute was open for public hearing, there were a number of stories told about how people would use their time to cover their FMLA and be left with nothing, and then they'd have to give up their opportunity to take the dream vacation they may have paid for, miss a wedding, or some significant event. So the intent here is that the paid time off that is left, those 2 weeks, is time that an employee can use for vacation, not necessarily sick time. So that's really the guidance that we're giving employers. However you choose to do that in your workplace is completely up to you, but that was the intent of this section of the statute. But if a worker doesn't get any employer provided PTO, then they will get the full complement of the paid leave benefit for the full time of the leave. If they get employer provided PTO that's equal to their full pay for the time that they're out, then they will not get any benefit at all because they don't have any wages that were lost as a result of their taking their leave, and there would be no reason to provide benefit. If they were receiving, for example, a part of it, and we'll go to this next part of the statute. So let's say that they were receiving part of it for part of the time. So let's say that the worker had 5 weeks of PTO. We'll just use a simpler example. And they're going to be out for 6 weeks. So the employer would have them use 3 weeks of their PTO, allow them to keep 2 weeks, and then the employee would come to the paid leave authority for the remaining 3 weeks, but they wouldn't do that until they've exhausted those first 3 weeks that they have in PTO full benefit from their employer. If what they receive is less than their regular pay, then we essentially pay the difference as long as it doesn't equal more than 100% of the worker's regular pay. Some things to tell workers in your various workplaces. If they're trying to figure out what benefits they'll get from the paid leave authority, there's a couple of things that they can do, a few things, one of which is that there's a benefits calculator on the prepare to submit a claim portion of the website, which you can direct people to. They should also determine whether the employer will require them or permit them to use some of their time while they're on leave. They should also be asking if there are any rules about using that time, whether they can use their sick time during caregiver leave, because there might be some restrictions or the conditions that apply to that. If your employer offers a short-term disability policy, they should know whether or not that exists, and they should know the terms and conditions of that policy. Some require that a worker exhaust all employer-provided PTO and state-provided benefits, which would include the paid leave authority, before they can access short-term disability, or whether it in fact then can be used concurrently and just reduces the amount that they would receive in benefit from paid leave. Now, a bit about family and medical leave. I mentioned earlier that not only are we implementing a new paid leave law that will allow people to access benefits next year, the family and medical leave law itself will be changing. Here are some of the responsibilities that we have. Let's see, let's go. Yes, let's talk about FMLA claims. So if a person comes into your office and says, I need to take family and medical leave, we're looking at two components, right? We're looking at whether or not they are eligible for family and medical leave under the statutory reasons for leave that I outlined earlier. And then you're also talking about wage replacement, which is what the paid leave authority does. They can be done at the same time, or they might be different. And that's why we make this distinction. So the worker's responsibility under FMLA is to let the employer know that they need to take time off, and they need to submit an application for that purpose. And they need to provide that employer with the supporting documentation and comply with all of the employer attendance and call-in policies around FMLA. If you're an employer that had 74 or fewer employees, you may not be familiar with this, which is why I'm reviewing it in the detail that I am. The employer is responsible, however, for making sure that they have the right rules around this, and that there's a family medical leave poster, which is available from the Department of Labor. to inform employees about how FMLA works and what their rights are and what their responsibilities are under the statute. The employer is responsible for submitting them for processing leave requests as they come to them, monitoring how that leave is used and when the employee returns to work. And again, to try to refrain from discriminating or retaliating against a worker for using FMLA. How can that happen, you ask? Well, here's how. It is not uncommon, and if you work at the Commission for Human Rights and Opportunities, they hear many of these cases where a person goes out on family and medical leave, and maybe they're replaced by someone who's wonderful. And maybe they do the job a bit better than the person whose job they're filling in for temporarily. And you want to keep the person who's doing the job, which we understand, but that's not legal. And sometimes employers do this and they say, well, I have the right to determine who should have that job. But if the person is taking FMLA, they have job protected leave, which means you have to bring them back to their job, even if the one who's filling it temporarily is doing a better job or a job that you feel is more in keeping with the way you believe that the work should be done. Doing anything other than that is discrimination and retaliation based on FMLA. And that's where the challenge comes in. And we really want to emphasize that because we see it happen often. And we want to make sure employers steer clear of that. At the authority, with respect to FMLA, we have no responsibility related to FMLA. We are providing this training because we know employers have a lot of questions about this, especially those that are new to FMLA, but we're not responsible for that. That is actually under the authority of the Department of Labor that promulgates the regulations. It provides guidance to workers and employers around FMLA, and it is responsible for investigating complaints regarding denial of FMLA claims and any claims of discrimination and retaliation. More detail about what happens with respect to job protected leave for FMLA. So the worker can come in and say that they need time off from work for a reason that is defined in the statute, but they don't have to say, I need FMLA. If they come and say, I need to have surgery and I'm going to be out for 3 weeks, that's FMLA. They should give you 30 days advance notice where it's foreseeable and as soon as practicable. Maybe they were in an accident or someone that they care for that they needed had an emergency. So that might not be practicable, the 30-day notice, but as soon as it's possible, they should do that. The employer determines whether or not they're eligible, and they tell the worker that preliminarily you meet the statutory requirement for FMLA and you need to provide me with documents. You have 5 days in which to make that decision as to whether or not the person may be eligible for FMLA. That's not the same thing as approving the leave, and you'll soon see why. Now, the worker is responsible for bringing back the required documentation, and they have 15 days in which to do that, meaning they have to go get a medical certification from their doctor or the person that they're caring for. If they have some trouble getting those things, they have another 15 days in which to do that. And the employer can extend it if they want to, but they don't have an obligation to beyond the 30 days. Once you have everything in your hands as an employer, you have 5 business days to make a decision as to whether or not that person does indeed qualify for FMLA and if you're approving that leave. And then you have to tell them how the leave works, whether they have to use their accruals, when they need to report in, and whether or not they'll be able to, they'll be required to provide a fitness for duty before returning to work if they are leaving for their own leave reason. Now, the worker reports to the employer when their leave is actually starting, and the employer has to then track so that they don't exceed the 12 weeks. The employer returns the worker to the job that they had before. So this is, again, the discrimination I spoke of earlier. And they don't necessarily have to be 100% fit for duty or totally recovered, because there may be some Americans with Disabilities Act or the Connecticut Fair Employment Practices Act obligations that you might have, which would require you to provide a reasonable accommodation for that person to return to work, depending on the size of your workplace. The ADA applies to workplaces that have 15 people or more. SFIPA, as we refer to it, applies to people who have workplaces of 3 people or more. This is not easy. There are lots of factors to consider when managing worker absences, and that includes workers calling in, making sure you're enforcing your attendance policies. They may not come back with all the right documentation. They may need to take intermittent leave, which is leave that's not in a big block. So they may be taking an hour a day or 3 hours on Thursdays and 2 hours on Mondays, because that's when they have to take their loved one to medical treatments. So that might be an issue as well. And keeping track of that can be challenging. In addition to workers who have fluctuating work weeks, and also, although it's more challenging now, you can have FMLA for the state and federal run concurrently, and that can be challenging too, because you have to manage some interactions. And it's very common, this last bullet, where people don't want their leave to be designated as FMLA because they don't want to start using it. But that is not the employee's determination. That is the employer. So in every circumstance, it is your right as an employer to designate the time off that qualifies as FMLA, even if the worker says, I don't want it. That is not their right. It is your right as the employer. So using the example I used earlier, if a person comes to you and says, I need to have surgery, I'm going to be out for 2 weeks, I have 2 weeks of PTO, I just want it to be PTO, I have 5 weeks of PTO, I just want to use 2 weeks of that, I don't want to count it as FMLA, that is not their determination to make. It is FMLA and it has to be counted as such. Just very briefly reviewing the job protected leave laws, as I mentioned earlier, all the ones on the left provide job protected leave, and I mentioned the ADA and the Connecticut Fair Practices Act, which may require reasonable accommodation, that's a whole other webinar in and of itself. And then we have the Paid Leave Act, which will also offer income replacement, and workers' compensation is also a form of income replacement. It's important to know here that a person who is receiving workers' compensation or unemployment benefits is ineligible to receive any paid leave benefit while they are receiving either workers' compensation or unemployment at the same time. I've covered a lot, but this is not the only time where you can do this. First of all, this is recorded, so you are free to watch it again. And we have another series of webinars. I think we have at least 18 more that will review it again. So, because I know it's a lot of information. We have a significant amount of information on our website. So we have employee rights posters that can be placed in your workplace if you're partially remote, or if you have people coming in. They can also be downloaded and emailed to people as well. And the rack card is a smaller version of the rights poster. The fact sheet comes in more of a question and answer format, because we know that people take in information in different ways. If you have not yet been withholding contributions, and I certainly hope that is not the case, but I know it might be for some employers, this paycheck mailer will explain to your employees what that 0.5% is all about. And there is an employer toolkit. This one says 2020. If you go to the website, the new one has been uploaded, and it does have all of the information I mentioned, including accessing benefits. There's also an HR toolkit on the website as well, which has everything that I just spoke about today. PFML, FMLA, how the law is changing, the differences between them. You'll see it all in those toolkits. So we're here to help. We do not have a call center. I hear this often. But it is not within our budget. Instead, we have a contact center that you can use through our Contact Us portal on our website, and someone will respond to you, and you can indicate there whether or not you need a call back. We also have a number of frequently asked questions and videos on our website, which is ctpaidleave.org. All right, and I will come back in. All right. I always forget to move that. All right.
Thank you, Andrea.
You're welcome.
So we do have quite a few questions in the chat. I have been kind of going through and getting to the ones that that I could. So I'm going to start up at the very top from Marjorie. She says, hi, we are really struggling with how we will supplement Connecticut paid leave with our short-term disability and PTO plans. Connecticut paid leave pays first. So how do we know how much to supplement? And how will we pay intermittent leaves when we don't know what Connecticut paid leave will be paying the employee?
All right. So, Marjorie, thanks for your question. I think it presupposes a few things, and I think I'm going to clear up some misconceptions. The way that the paid leave process works, it isn't done in a vacuum. When the employee, I'm just going to close these questions. When the employee comes to you and says, I'm applying for paid leave, Aflac will be in touch with you, and there's a form that you're going to need to complete that will tell us that the employee has either PTO, some other time, a short-term disability policy. So we'll know that in advance. So you will know, and we will know, and then we will tell you that the employee's benefits have been approved and they are getting X number of dollars. And then the difference between that will be maybe what your short-term disability policy will cover, if that is in fact how it works. So it will be a situation that depends on the terms and conditions of your short-term disability policy, and will also determine how much the person is getting from paid leave. So it isn't as if they're coming to paid leave and saying, all right, I'm going to get, let's say the person's paid $500 a week, and I'm going to get $425 from paid leave and their short-term disability, and then the employer's just kind of left to figure out what the difference is going to be. That those dollar amounts that you provide to us and that information allows us to determine what the benefit will be. And as an employer, you will receive notification, and it will also tell you what the difference is between what we know their weekly wages that they're eligible for and what they're being paid. And that way you'll know what to do with respect to short-term disability.
All right, thank you.
Well, I think another part of her, before we go on though, Amber, I think another part of her question was about intermittent leave.
That's what I was moving to next. Thank
I'm
you.
sorry. Okay. Yeah. So the answer really isn't very different, whether it's a block leave or intermittent leave. Intermittent leave, we all know, is much more challenging to manage because it isn't in a big block and it can change based on the person's personal or health circumstances. But intermittent leave at the Paid Leave Authority, we are requiring those that have intermittent leave to check in with us periodically. So right now, I believe it's every week or every 2 weeks, the person has to go in and put in the hours that they've worked and whether or not they're receiving any additional benefit from their employer. And then that's information that we can communicate to the employer if we see that it varies from what they initially gave us in terms of their schedule and how long they would be away and if there's any changes at all. So you can still pay that intermittent leave from the information you get from the beginning, but if it changes, we will be asking the employer about that change as well.
Thank you. And to piggyback onto that, will the Connecticut FML and Connecticut paid leave cover the same family members in 2022? For example, will siblings be covered under the Connecticut Family Medical Leave Act?
Yes. Okay. Yes. So the FMLA, this is why I really wanted to spend time, and I know it's probably repetitive for those who are very facile and conversant with it, but family and medical leave is changing, and it applies to employers with one or more employees. So even if you never had it before, if you have one or more employees and someone comes in and says that my sister is sick and she needs treatment and I need to take 3 weeks off to take care of her, it applies. And then they may also say to you, and I'm going to apply for benefits at the Paid Leave Authority so I can get paid while I'm out taking care of her.
All right, thank you.
Mm-hmm.
An employee starting maternity leave in October 2021, can they apply for Connecticut paid leave as of December 2021 for any time that they are out as of January 2022?
Yes, but I'm seeing a bunch of questions before that, Amber. So I'm looking at one that says, does that mean that a new hire can be with the company for 2 weeks and be eligible for paid leave?
That's a separate question. This one got shuffled to answer on accident.
Okay. Okay. So could you repeat that question for me then?
Sure.
Okay.
Okay. So an employee starting maternity leave in October 2021.
Yep.
They want to know if this person can apply for Connecticut paid leave as of December 2021 for any of the time that they are out as of January 2022 due to pregnancy or maternity.
Yes, they can. Yes, they can. Not only that, they're eligible to apply for bonding leave for up to a year after for up to the time that the child turns a year old.
Okay.
So yes, they can.
All right. And then I would say, let's move to that last question that you had read.
Okay. So does that mean that a new hire can be with the company for 2 weeks and eligible for paid leave? Yes, that is true. And so the way that works is that there's different eligibility requirements for paid leave and family medical leave. So someone can come to you having only been at your workplace for 2 weeks, but if they've worked somewhere else and they've left that job and they've worked there for 12 weeks and they've earned $2,325 in that highest earning quarter of those 4 of the 5, which is defined as the base period in the statute, and they have a reason for leave that's covered in the statute, and they haven't exhausted any of their FMLA, they certainly can come to you 2 weeks into their employment and say, I need to take leave because I now have this serious condition that requires surgery or treatment. Now, your response as an employer can be, that's fine. You may be eligible for family and medical leave. For paid leave benefit, let's make sure that that's clear, for paid leave benefit, but you don't have any job protection because you've only been here for 2 weeks. So we're not holding your job for you, or you can reapply, or we will hold your job for you if you're going to be back within, I don't know, 3 weeks after your treatment. That's up to the employer. But yes, that is true. You can have a person apply for paid leave who doesn't enjoy job protection and be with you for a very short period of time.
All right. And while the 2 weeks, the individual is waiting for their check from paid leave, can that person use their accrued vacation time?
Yes, they can.
Okay. And what is the employer's role in the claim process?
Okay. So the employer's role in the claim process is to complete the employer verification form that you're going to get from the worker when they bring in their welcome packet. So their welcome packet has a long checklist of all the things that they need to provide in order for us to determine whether or not they're eligible for the benefit. And one of those things is an employer verification that tells us the person works there, how much they work, whether they have any benefits to offset it, whether they have any PTO, how long they've worked there. There's a whole host of information that we'll be asking on that form. The person has to bring it to you, you complete it. It's their responsibility to make sure that it gets back to us at the paid leave authority. Okay. Whether they ask you to return it, which we prefer, and there's a simple way to do that. You can upload it, you can email it, you can fax it. There's all kinds of ways to do that. That way we know that we're getting it back directly from the employer and that there hasn't been an opportunity for the form to, I guess, acquire additional information if it takes a different route. But yes, that's the employer's role. And then after the claim has been determined, let's say that there's an approval process for the claim and the claim has been approved, then the employer is responsible for tracking those 12 weeks of FMLA to make sure the person doesn't exceed their time.
Okay. What if the employee is the one requesting to be paid out all of their PTO while on Connecticut paid leave? Should this be denied?
So the employee has the right to pay out all their PTO while out on FMLA. So it's not CTPL, it's FMLA. But you should let them know, and I strongly recommend that employers do this in writing, that they have the right under the statute to keep their 2 weeks. They're choosing to forfeit that. And as a result of that, they will have 0 days, 2 days, whatever it is that's left. And they know that they're going to be subject to whatever the company policy is for exceeding the amount of time off that they have or taking time unpaid. They know that they understand what those rules are and they're willing to abide by them. That's how that can be handled.
Okay. Our company currently has a sick pay continuation program where employees receive full sick pay for approved FMLA events. In 2021, can we direct employees to receive Connecticut paid family medical leave payment instead of our company sick pay?
Well, if that's your policy, then you can certainly do that. But I will tell you that we will be asking whether or not that sick pay continuation program exists. And if it does, then we would and if the person is required to access that, then they access that first. And then when that is exhausted, they come to the paid leave authority.
Okay. An employee may want to use some PTO for 100% pay. How is that communicated to Aflac, confirmed with the employer, and counted towards their 12 weeks of Connecticut paid family medical leave?
So when they file their application, that's part of the information that we will be confirming with the employer and with the applicant. So if they're going to use 2 of their 3 weeks of PTO by their own decision for their pay, then they will let Aflac know that, and we will confirm that with the employer. This is all part of the workflow that Aflac is responsible for. And then that is indeed counted toward their FML max. So if they're using it and they're not accessing FML benefits, then they would still have those numbers of weeks available to them under family and medical leave. Although it will still, let's say it's 2 weeks that they want, then out of a 5-week time period that they want to take off, they will have still 10 weeks of FMLA, but they will have 12 weeks of family and medical possibly qualifying PFML, but they won't be able to use all of that because they've already used 2 weeks of their qualifying FML.
Okay, thank you. Is there a waiting period for the Connecticut paid benefits to start, or do they start as of the first day of leave?
So they start as of the first day of leave. There's no waiting period in the statute, but we do pay 2 weeks in arrears.
Okay. And when will the Aflac company or state of Connecticut provide more details on submitting claims for Connecticut PFML? Will this happen prior to December 1st?
So if you go onto our website, under the section that's entitled the process, and if we have just a couple of minutes, but I don't want to take away from answering questions. If you go onto the website, on the top of on the landing page, the home page, there's an arrow there's a on the banner, there's a section there called the process. When you hit that, the first thing at the top is to prepare to submit a claim. If you go into that section, it will highlight for you in a lot of detail what you need to do to submit a claim for paid family medical leave. So it's
Thank
already
you.
there on the site.
Thank you, Andrea. And just so everyone knows, I did copy and paste that link into the chat for you. Can you explain how the employer will be notified of an improved leave in terms of paid leave benefits?
Yes, so you will receive an email. That's why it's important that when you fill out that employer verification, that you give us the right contact information and the right person that the email should go to. So once a claims decision is made, you will be notified of either the approval or the denial of that paid leave benefit for that employee. So if they decide to go out and they tell you they have paid leave benefit, you will have something from us to compare that information to, and that way you will have a basis for a conversation with the employee.
Okay. Does the amount of Connecticut paid family medical leave affect the amount paid by short-term disability and vice versa?
It really depends on your short-term disability policy. So some require that all employee available time and state available benefits be exhausted first before they pay anything. Some allow you to receive whatever your short-term disability is at the same time. So it depends on how the policy works. So if, for example, short-term disability offers 60%, the person can then come to the paid leave authority and get the other 40% of their weekly pay, as long as it doesn't exceed 100%.
Okay. And what type of certification would someone need for bonding leave?
Right. So this is within the purview of the Department of Labor, and they will be issuing specifically what a person will need for that type of leave. But I can tell you very generally, you'll need to provide some sort of proof that you're expanding your family through birth, adoption, or foster care, and that you will need that time in order to bond with that new child to your family. This is usually not difficult for people to get: birth certificates, certificates of adoption, certificates of documentation by adoption agencies, certifying placement of the child in your home. Those are the types of things you would need generally to get bonding leave.
Okay. For maternity, assuming, I'm going to change the verbiage on this a little bit for flow. Assuming this person is taking 16 weeks for maternity leave, the employee has a baby in December. Is there any way that if they have the baby in 2021, they'll still get 16 weeks?
No.
Okay.
It's a 12-week leave in a 12-month period.
Okay. And I believe we had another question almost similar. Are employees who had babies in 2021 eligible for the full amount of baby bonding leave, regardless of how much time they took in 2021?
It's a 12-month look back period. So if they've taken leave, you're looking 12 months back from the time that they're applying for leave. If they've already taken that time, then that time is subtracted from the time that's available for them for leave.
Okay. How are required deductions, for example, health insurance premiums, for employees to be handled by employers while the employee is out collecting Connecticut paid leave and receiving no wages?
So they're not receiving wages from the employer, but the benefit that they're receiving from paid leave is considered wage replacement. If your company requires that they continue to pay their portion of the health insurance and any other premiums in order for their participation in your group health plan to remain current, then they're responsible for sending those payments to you directly. If they don't do so, then you would follow the same policy that you would for any other employee that is failing to pay their health insurance or their other type of premium, which can include their exclusion from the plan, but they should know that. And so when you are approving their FMLA and they're going out, you should tell them that in their letter. This is your FMLA is approved. This is what you still need to pay for your health insurance, your dental, your long, your short-term disability. If you're receiving benefits from the paid leave authority or your own short-term disability policy, you still need to send us that money. And if you don't do so, then you risk losing that benefit.
If the employer pays holidays or has a policy that pays more than Connecticut paid family medical leave, can the employer get the benefit payment as a reimbursement so that it is counted towards the employee's maximum leave?
No, the statute has no provision for reimbursement.
Okay. This group was told by Connecticut Paid Leave, if an employee gets PTO during those first 2 weeks, those 2 weeks would not be counted towards their 12 weeks since Connecticut Paid Leave is not paying them for those 2 weeks. Is this correct?
No, my first answer was correct, but Marjorie, we can talk offline because I think I know when that question was asked, and I think the circumstances were different. So let me find out.
Thank you.
Okay.
If an employee has regular salary of $1,000 per week, can they collect $780 from paid leave and $220 from their accrued leave PTO so that they are kept whole?
They can. It also depends on your employer's policy. So if you require them to use all of their time at 100%, then they would get that first, and then they would come to the paid leave authority after that. If they used to choose part of their PTO, which is what this example is, and come to the paid leave authority, but that's in contradiction to your company's policy, then we're going to question that at the paid leave authority and tell that employee that they need to follow their company's policy and then come to us after that. If it's permissible under your policy, then they can do what's being suggested in this question.
Okay. You had mentioned 2 weeks of accrued time in the balance. Does that have to be 40 hours per week? What if the employee only works 20 hours per week?
No, it doesn't have to be 40 hours. It's whatever their 2 weeks of accrued PTO is based on their work schedule. So you don't have to add more to that to make it a 40-hour work week. If you allow your part-time workers to accrue PTO, you would give them the ability to keep 2 weeks of whatever is equivalent to their 2 weeks of work.
Okay. Is there an employer portal online to track claims? What if an employee provides the incorrect contact information when they submit their initial form?
So no, there is no employer portal online to track claims. It is strictly an employee paid benefit. So each individual employee will have an ability to sign in, create their own account, and to track their own claim. If the employee provides the incorrect contact information, then Aflac is instructed to continue to find out what the correct information may be. So you may receive a letter, a fax. There are other places where we can get employer information, including the Department of Revenue Services and the Department of Labor, the Secretary of State. There are other ways that we can find where employers are if an employee happens to provide the incorrect contact information. If they do so and we can't get in touch with the employer, then that could affect an employee's ability to continue to receive that benefit.
Okay. Our company has 100% sick pay continuance plan. If we don't change that plan in 2022, then employees will receive their sick pay from the company. Does this mean our employees are paying the 0.5% tax for no reason? Or perhaps we would need to withhold this in the event they leave and work for another employer?
Okay. So again, this has to do with what your particular plan is. We know that there are a number of employers who already have different types of plans, like the one that you described, where you already have 100% pay. The 0.5% is a contribution to the trust fund, which is an insurance plan. So yes, there will be circumstances, and there are right now, where people are contributing the 0.5% and they may never use the plan because their employer offers a plan such as yours. But then there are circumstances where people may leave an employer such as yours and move to another that does not offer a 100% sick plan. And those people will then eventually come to the paid leave authority and look for that benefit. So while they may not be using it now, we do know from the experiences that we have and have learned from other states, which would be Washington, Rhode Island, New Jersey, California, Hawaii, that people do tend to move from employer to employer. So while they may not access the benefit at one employer, it's more likely they'll access it at another. And that's why they're paying the 0.5%.
Okay, thank you, Andrea. And our last question, we're at 1:31.
We
Will
are.
the employer have a representative at Aflac to contact for issues that come up? If not, how will the employer address and answer questions that come
Okay.
up?
So it depends on what those questions are. The employer will be able to address those questions through the contact us feature on our website. And our contact center is staffed by the United Way. So there are folks there who are qualified to answer those questions. And in addition to that, we have people on our staff who are business support specialists. So if your question comes in, you need a call back, you have a specific concern, there will be people on our staff who will be able to respond to those questions for you. We do not have direct lines. We work remotely. I know this is frustrating for people, but we have a very tight budget, and almost all of the money that we have needs to be available to pay benefits. So we don't have the same level of support that other agencies have. And I get that, and we all get that, but we're doing the best that we can with what we have through our United Way and our business support specialists in order to be able to get you answers to the questions that you need.
All right. Thank you, Andrea. That concludes our questions for today. I just want to thank everyone again for joining us. And as a reminder, you will receive an email from me with the links to this recorded webinar, as well as a PDF copy of this presentation. Thank you so much, everyone. Have a great day.
Thank you.